Hi, I'm Locke Meredith with Legal Lines. Mediation, what is that? It's nothing but a big, fancy legal word for parties coming together and trying to figure out how they're going to resolve a dispute without going through the litigation process and all the costs and the hassle associated with it. We've got John Perry, who's mediated over 1,700 cases on the show today. So join us on the next Legal Lines.
Almost half of all parents who suspect their child has a problem learning wait a year or more before getting them help. Why? When there's so much they could be achieving. Kids with learning disabilities are smart. They just learn differently. Call or visit us on the web now.
Hi, I'm Locke Meredith with the Legal Lines. We're very honored today to have with us John Perry. He's an attorney here in Baton Rouge and has been a defense lawyer, a plaintiff lawyer, a judge, and now we call him the mediator extraordinaire. John, thank you for being on the show.
Happy to be here.
Let's talk about mediation. What is mediation?
Well, it's interesting. Mediation is a form of what we call alternative dispute resolution. When I got out of law school in 1978, no one knew what that was, 24
Nobody
years.
did it.
No one did it. And I would say the last 5 years it's really, taken off because the court systems, and people generally know this, the court system is backlogged. It's a time-consuming, expensive, and sometimes inefficient process to resolve lawsuits and disputes.
Sure not fast, is it?
It usually is not, and litigants, society, everyone has looked for other creative ways to end disputes, avoid the inefficiencies and the expense of litigation. So mediation is a process that most people are familiar with generally. I mean, mediation is the process that they're trying to settle the Palestinian-Israeli crisis. Mediation is the process by which they're trying to resolve and settle the East Baton Rouge Parish School Board desegregation case.
A big word for saying bring the parties together, exchange the information and strengths and weaknesses, and see what you can come up with.
Yeah, the way it works is very simply as you described it. A mediator is selected generally by agreement. Sometimes a court appoints a mediator, but it's generally by agreement. The parties pick someone who they think would be effective. All sides come prepared with their lawyers and the parties involved on both sides. Generally, the mediator is given materials to become familiar with the issues.
But he's not a judge, is he?
No, a mediation is, the hallmark of a mediation is self-determination. The parties resolve the case by agreement and consent, hopefully through that process. That's the objective.
And when we say resolve, we're talking about they settle.
They settle, it's over.
Settle the case.
The objective of the mediation is to put an end to the dispute. It usually results in a written stipulation or agreement that's followed by the exchange of money or the exchange of released documents. It's distinguished, mediation is distinguished from an arbitration.
Which is what?
An arbitration is a mechanism by which a dispute is resolved by an arbitrator.
Outside of the court system.
Outside of the court system, but it's binding.
Meaning the arbitrator, the guy who we would say is kind of similar to a mediator, but this time he's got some power.
Yeah, and I have done a number of arbitrations. They're fewer in number than mediations, but when I'm selected to serve as the arbitrator, I'm basically appointed by the parties by agreement to be the judge. And I hear the evidence on both sides. The parties can submit argument and briefs just as you would to a judge in court, and I make a decision, and that decision is final. The important thing is it avoids the extended legal proceeding that might take forever and might be very expensive, but it's also not appealable.
Which is interesting, isn't it?
Because if you go to court and a judge or a jury decides your case and you don't like the outcome, you can go to the First Circuit Court of Appeal. Judge Downing has been on this show recently, and he's a judge on the First Circuit Court of Appeal, and then you can go to the Supreme Court, the Louisiana Supreme Court.
And then that takes a long time.
Takes a very long time. The biggest distinction, as we said, is the difference between binding and not binding. Because when I'm a mediator, I tell people at the mediation I have no power. I can't force you or your clients to do anything you don't ultimately agree is an appropriate concession to make. I can't force the other side to make concessions they don't want to make. So I tell everyone when we start that if we're successful and the case is resolved, everyone will leave equally dissatisfied.
Now, I pointed out in the beginning that you've been a defense lawyer for how many years?
16, a little over 16 years.
And when we say defense lawyer, we're talking about a guy who does what?
I defended primarily civil lawsuits on behalf of insurance companies and corporations and self-insureds, but it was on what is generally regarded the more conservative defense side. I was defending lawsuits that were filed in the civil arena.
By the plaintiffs?
By the plaintiffs.
And then you did that for how many years?
16, a little over 16 years.
And then you did some plaintiffs' work for what? How many years?
I then went and did almost exclusively plaintiffs' work for a little over 3 years and continued to do some until I started my new firm. And now I do some defense work, some plaintiffs' work, and quite a bit of arbitrations and mediations.
And you were actually a judge ad hoc, in fact, for Judge Downing.
Yeah, when Judge Downing got elected to the First Circuit Court of Appeal, there was a vacancy for 6 months until a new judge was elected, and I got appointed by the Supreme Court and sat for him, and really enjoyed that.
So you have seen all sides.
Which has helped me develop and grow my mediation practice, because I've now had the privilege of mediating 1,700 cases in the last 5.5 years. So I've done quite a bit of it, and it's a really enjoyable part of my practice.
So based on having the defense perspective, plaintiff perspective, the judge perspective, why does this work? It's just because it's quicker and cheaper?
Well, it's interesting because the truth is the moon and the stars line up for mediation, because even though litigation is adversarial, and when you file a lawsuit against a company, generally there's some big disagreement that prevents the case from being resolved. That's why it goes into litigation. But the defendant has the choice of paying its lawyers and its legal team, maybe for years, to work through the inefficiencies of the system, to go all the way through a jury trial and all the way through appeals. They don't want to do that anymore. You know, if they can resolve it in 3 months as opposed to 3 years, everybody will choose to do that every time in 3 months. On the other side of the equation, someone who has been aggrieved or who files a lawsuit or has been a victim or who needs to have his or her case litigated would much prefer to have it resolved quickly as opposed to inefficiently.
Right.
So both sides show up with built-in incentives that are totally compatible and that are totally aligned. Even though they're adversaries in the system, they have the same common goal of avoiding unnecessary legal fees, avoiding unnecessary expenses, avoiding unnecessary delays. So despite the disagreements, it's a very successful process. Because
I really thought when it first started coming on the scene that it was a waste of time. I said, I'll never do that. It's going to, you know, sit down for a couple hours and nothing's going to happen. Why can't we do this over the phone? But it's productive.
Well, what is your view now that you've participated?
I think it is absolutely a step that you take in the litigation process. Hopefully it's successful. And my view is that because you have all the parties who are making the relevant decisions there at the same place with their respective consultants, attorneys, whatever you want to call them, you have a shot at resolving it. You don't always resolve it, but you got to get ready, and reasonable people hopefully can reach a reasonable decision.
Although we ought to talk about the success rate, because in my experience, probably 80% of the cases that are submitted to mediation successfully resolve, and it's generally regarded by most people as a very, very, very successful process.
The courts have actually really embraced this process, haven't they?
Absolutely. I get, you know, in Louisiana, mediation is voluntary, not mandatory, but the judges are very much behind it.
All right, on the next segment, let's talk about the mediation process and how that takes place. I'm Locke Meredith with the Legal Lines, and we'll be right back.
I wasn't going to school because I was making money stealing cars. Well, I was 10 when I first got involved with drugs. I skipped school because, you know, nobody cared.
When I first got pregnant, school was not important to me, so I dropped out.
Well, if I don't finish school, then I can't go to college. I mean, that's the whole point of what I want to do with my life.
I still need to go to school to make it for myself.
I think I'm happier now. I know I'm happier now.
Welcome back. I'm Locke Meredith with Legal Lines. We're privileged to have John Perry on the show with us. We're talking about mediation. John, let's talk about the practical aspect of mediation, how it affects the judiciary, how it helps judges handle that huge caseload. Judge Calloway was talking about 20,000 cases in his section. Tell me about that.
Well, it's been an interesting evolution, and I always go back to 1978 because that's the year I graduated from law school 24 years ago. No one knew what mediation was. No one knew what alternative dispute resolution was. And now, just about every law school has a course on...
Is that right?
It's called...
I know we didn't take any courses in that, did we?
It's relatively recent, but it's ADR, alternative dispute resolution. 10 years ago, there were no mediators. Really, it was very seldom used as a process. Now the Bar Association publishes all the lawyers who are trying to build into their practices a component of ADR as either an arbitrator or a mediator. And there are literally hundreds of lawyers in Louisiana who are trying...
Is that a good thing or a bad thing?
I think it's a very good thing because we're getting, you know, very, very talented people who have tremendous experience after 20 or 30 years of practice in a given particular field, and they have a lot to offer in terms of being able to resolve disputes. For example... Wisdom and, you know, specialized knowledge. I've mediated 1,700 cases, but that doesn't mean I'm the best mediator for a particular case. I mediated a construction dispute the other day, and I haven't done any construction law, and I don't have a construction background. You know, someone who has done that for 20 years.
And that's an important point, is that anything can be mediated. Family court mediates issues.
Family court mediates issues. Businesses are now internally trying to mediate disputes before they even get to the lawyers. The school board's trying to mediate the desegregation case. The United States government mediates all the time throughout the world. And look, we know that of all the hundreds of thousands of lawsuits that get filed throughout this country every year, fewer than 5% actually get to trial. So we know they get resolved somehow. And the judges have embraced mediation and arbitration as...
They got to have it to make the system work.
In fact, most courts have pilot programs or mediation panels where they refer cases out. My preference is that it be done voluntarily because I think there's a much greater likelihood of success if the parties have committed voluntarily to participate.
They're both motivated.
As opposed to saying, I'm forcing you to go to mediation.
You know, we had Judge Calloway earlier and Judge McDonald and several other folks, and they have themselves participated in trying settlement conferences, trying to resolve it, but this saves them time.
Well, and when I was a judge briefly, when I took Judge Downing's position, you have so many demands on your time with motions and status conferences and pretrial conferences and trials and opinions that have to be written and briefs that have to be read. You know, mediation can be a time-consuming process, and judges don't have 3, 4, 5 hours a day to devote to a settlement conference in one case. Now, some judges are very good at settling cases and participating in settlement, but it frees them up to do the things that they need to do on the important issues that are before them in important cases if, you know, litigants in many other cases are out privately mediating.
You know, interestingly, too, we talked about issues, we'll talk about strengths and weaknesses, and there may be a legal issue that is hindering a settlement, and you will be presented with position papers that will outline the law and the various jurisprudence, and you kind of bring to the table an unbiased perspective and an analysis of that, and that also helps. Basically, you're not a judge, but at least you're analyzing it from a third-party, unbiased perspective.
Yeah, and different mediators have different approaches, but most good mediators, I think, are active participants in the process, and the number of creative ways that you can use to settle cases is almost unlimited. I tell my engineer friends who have trouble with the legal world, that 2 + 2 can equal 5 if we shake on it. And you use the example of a very difficult legal issue. I had one the other day where there were probably 8 or 9 issues in the case. We got the whole case resolved, but there was one central legal issue that was in dispute. And I said, why don't we agree to settle the case conditioned upon the court system resolving the one legal issue, and the loser can appeal and go through the process.
So you streamline it.
We streamlined it and narrowed it to one issue. Now, we settled all aspects of the case except that one issue.
And that should be resolved via a motion for summary judgment.
Cross motions for summary judgment.
Not expensive.
One hearing, and whoever loses. And usually when you get it focused to that extent, it'll ultimately get settled. And it did, because the parties decided they still didn't want to go to court even on that one issue. The thing that motivates the parties when you get to the red zone of a settlement discussion is the risk and uncertainty of what's going to happen if you go to court, because usually it's a jury trial if it's a big enough case, and it's very difficult to predict what 12 strangers to the case are going to do on a given day, and there's risk to both sides that can be avoided by a compromise.
You know, you were talking about the motivation of defendants and plaintiffs. You get referrals from both. There are requests that you mediate from both defendants and plaintiff side. Do you see it being an equal desire by both sides, I guess in the context of categories?
Yeah, I would say initially, for some reason, the plaintiff side of the world was a little bit skeptical. But now I would say that the enthusiasm for participating in mediation is equal. I mean, both sides, you know, want to participate in the process. Now, there's still some jockeying for position over when is the right time, who the mediator is going to be, what the location is going to be. But gaining the voluntary consent of everyone is not a problem, because just about every case in the system gets submitted for mediation before the end of the day.
You know, we've often talked, and I've heard from your lips and other mediators' lips, a good mediation is one where both sides leave kind of ticked off and not happy. Why?
Well, I mean, the court system and going to court and fighting it out is for winners and losers, and at the end of a jury trial, someone generally leaves exhilarated that their position has been vindicated, and another side leaves very disappointed and despondent that their position wasn't accepted. You know, that's the risk you take. Somebody's going to win and somebody's going to lose. Somebody's going to be happy and somebody's going to be very upset, generally. Mediation, no one gets a home run. You know, if $1 million is your best case scenario, you know, if you tried the case 10 times, you might get $1 million once. You're not going to get $1 million in compromise. You're going to have to make concessions, you know, to settle the case. Bird in the hand's worth two in the bush. And most human beings will take certainty over risk and uncertainty in any aspect of their life, but particularly in the stressful environment of a lawsuit.
And it boils down to compromise. Let's talk about the process of mediation. Describe it in our next segment. I'm Locke Meredith with the Legal Lines. We'll be right back.
Make contact.
Make friends.
Make fun.
Friends.
Trouble.
Make a point.
Make it happen.
Make believe.
Like
good.
Make new.
Make
Clear.
Make up your mind.
Make peace.
Make inroads. Right.
Reference.
Make change. Change.
Make acceptance.
Make hate.
Make something.
Make a stand.
Make art. Make a difference. Make a difference.
Make noise.
Welcome back. I'm Locke Meredith with the Legal Lines. We're again honored to have with us, not judge, although he's been a judge, John Perry. We're talking about mediation today and the process and how effective it is. John, let's talk about the process. We've talked about what mediation is, basically getting the parties together, seeing if they can reach an agreement on how to resolve and settle and walk away on a dispute. Let's talk about the process. How does it start off?
Well, it starts off generally with an opening session where all the parties and their lawyers are together in the same room with the mediator. Number of reasons for that. One is to help the mediator become acquainted with the issues to the extent that hadn't happened before the mediation.
Because again, you mentioned previously, at least in your case, you ask for position papers, and the parties will outline the facts and the issues and various
Right, so
matters.
usually I come in prepared. I like to come in prepared. But once a lawsuit is filed, it's generally an adversarial, stressful, awkward situation. The parties don't talk to one another except through their lawyers.
Right.
But in the opening session, the parties, through their lawyers, can speak to one another on a very informal basis and explain, their perspective.
Now, something important that we need to note is everything that's said during a mediation is not admissible in court. In other words, if somebody, let's say a defendant comes in and says, for purposes of this gathering, I'm going to admit that my guy screwed up and he's at fault, doesn't mean I can use that against him in a court of law.
That's right. The law promotes settlement and thus makes all settlement discussions confidential and is not, admissible at trial. And so therefore it promotes people being forthright, more frank, because if the process is unsuccessful, their positions and the statements they make at the mediation cannot be used against them in court, which is helpful. But the opening session generally is to promote an atmosphere of, look, despite our differences, despite the hard feelings maybe, despite whatever the issues are,
We're here.
we're here for the purpose of reaching a resolution. Everybody's here in good faith. Everybody's here, trying to achieve the same objective. And in the overall spectrum of life, we all need to move on and kill the lawyers, kill the litigation, and put this behind them.
Something that I found that's very kind of foretelling almost in mediations that I've participated in is whether or not I bring with me my clients and the defendants bring with them a person with authority who can really either make the decisions or has access to somebody who can.
Well, it's and you hit the nail on the head, because the plaintiffs generally always come with the human beings who are involved in the case from their side. Defendants sometimes, for example, if a corporation or an insurance company is the defendant in the case and has a representative in Philadelphia who is actually the person with authority to make the decision, but he or she does not want to come to Baton Rouge and they're going to participate by phone, it's a much more difficult process.
Because they're not there to see the people.
They're not
there to hear the arguments.
And it's easy in the midst of continuing to do your work in Philadelphia to pick up the phone when the mediator or some lawyer calls during the mediation and just say, no, I don't think I'm going to make that concession, and no, I'm not interested, and I think they're being unreasonable, and see you later.
The other interesting thing, too, is on the plaintiff's side, I think it's not doing a service to your client if you show up at the mediation and you haven't sent the defendants all your medical records and all of the expenses and your lost wage data and all that, and you show up and expect them to analyze that information on the spot. It doesn't happen that way, does it?
No, and we've seen it all, and you've seen quite a bit of it as well. It's important that you pick the right time to have the mediation. And a lot of mediation sessions are conducted prematurely before all the relevant information has been exchanged, and then people hate in the middle of a mediation to be hit with new information that they have to react to spontaneously, because truthfully, on the defense side, there's more of a bureaucracy to get through in terms of connecting the dots to get settlement authority and have the decisions made.
And you can't blame them. They're dealing with usually significant monies, and they want to see the objective evidence that supports the plaintiff's position.
Right, and the good lawyers on the plaintiff's side know what the other side needs and doesn't wait necessarily to be asked for the information. They put it together. The best thing to do is put yourself
in their shoes
on the other side of the table. What would you want to have, and get it to them. I mean, Tip O'Neill, I tell people in mediations all the time, Tip O'Neill used to say, where you stand determines where you sit. I mean, where you sit determines where you stand, because everybody's got a different perspective. And the good plaintiff lawyers put themselves in the perspective of the defendants and make sure as early as possible, that they get the information they need.
That's right. Well, We meet in a common room, and the plaintiff gives his position, and it's adversarial, or it's you know, definitely skewed to make sure that all of the positive aspects of his case are presented. And then the defendant comes in and stares the plaintiff in the eyeball, the defense lawyer, and he says, look, you know, I like you, I respect you, but here are the weaknesses that I see in your case, and here's why we're not going to pay you a gazillion, jillion bucks. And then what happens?
Well, I tell people 95% of mediation is conducted privately in separate rooms, and the different parties, and I've had mediations with 10, 12 parties. Usually there's a plaintiff side and a defense side, but sometimes it gets more complicated than that. But
Somebody else pointing the finger at somebody else down
that's
the
right.
line.
That's right. And they all go into separate conference rooms, and then the mediator meets privately with everyone involved. But it's easier to be more forthright and more forthcoming when you're talking to a mediator privately. And there's a big distinction between the information that is on the record and the information that's given off the record, because I encourage people to understand that confidentiality is a big and important part of mediation. I've been in many cases, and you have too, where it looks hopeless 3/4 of the way through the mediation. You're not in the same hemisphere. It doesn't look like you're going to ever get to what I call the red zone.
Right.
And, you know, somebody wants $1 million, and the other side's saying, I'm not going to pay more than $100,000, and the gap is,
Big gap.
it's time, you just think it's time to go home. Well, I can talk to people confidentially on a hypothetical basis, privately. And if I determine in those confidential hypothetical discussions,
When you say hypothetical, what you talking about?
well, I'll say this, Locke, you're telling me that you want $1 million and you're not taking anything less than $1 million, and this is a waste of time and we ought to go home and the litigation's going to continue. You're not telling me that if they offered you $500,000, you wouldn't pause and seriously consider it, are you? And I said, tell me in confidence that if $500,000 were on the table, that you'd walk out of here as cavalierly as you're now telling me you're ready to walk out of here.
And then you go to the defendants and do the same thing.
I do the same thing or something very similar, and I can instinctively sense whether there's any ability to bring the parties together.
And 80% settle.
At least 80% of the cases
And of
settle.
those that don't settle, what percentage of those ultimately settle?
Probably 80%.
So it's a very, very productive process.
Very productive process. We know that only 5% or less of all lawsuits that get filed get tried in the
And
court system.
ultimately, that makes our judicial system work better.
I think so.
John, it's a great service you're doing for us. Appreciate you being here, and we look forward to having you back.
Thanks for having me.
This is Locke Meredith with the Legal Lines. Thank you for being with us.